Starting out these hearings. Because that is what you would be suggesting by saying it doesn't matter. Notice rules don't matter. Doesn't matter if anybody who's here found out accidentally or inadvertently. Thank you. That's all I have to say. Thank you.
Thank you. Just a second. Response.
Mr. Hearing Chair, or Chair, Steve Blair, General Counsel for the Department of Ag and Natural Resources. You know, Mr. Ellison's comments are well taken regarding just the sort of general context, if you will, of due process notice and opportunity to be heard. It's clear from the record that a formal notice of hearing wasn't issued in this matter. You look at the board's rules. It does say that notice would be provided. The hearing chair indicated at the pre-hearing conference that notice would be provided. I guess the question that arises is whether the agenda that was posted on the 6th of February, according to the Boards and Commission's website, so approximately 2 weeks ago, whether that provided adequate notice to the parties. And I think you could make arguments on both sides of that issue. There's certainly a number of interveners here today. I don't know if all of them are here. I don't know if all of them intended to be here. You know, I don't know if we have any way of making that type of a record today. There was certainly notice provided to some. And so I think the question before the board, and I would defer to the board, is whether the posting of the agenda was adequate notice to the parties to allow them to appear today and be heard on the issues that were raised. And I don't know if any of the interveners that raised appeal issues were unable to make it, or if they're all here today. And that would certainly be an issue that I think could be considered by the board. If everybody who wanted to bring appeals before the board is available, or whether they were not able to be available. That would be the department's position. Is there's arguments on both sides, and I think it's left to the discretion of the board whether that posting of the agenda was adequate notice of these matters.
Mr. Chair, thank you. Matt Nas for applicant Clean Nuclear Energy. Jeremy Poirier, company representative, intends to join us today. However, flying from Denver can sometimes be challenging, and his flight has been delayed from early afternoon yesterday until maybe noon today. We'll see. But to respond to the motion for the continuance, clearly, to the extent notice is required, it's been waived by the intervener's presence here today. It was sufficient to put the interveners on notice of this hearing and that these matters would be considered. That was done at least as early as the timing the notice of continuance was filed. You know, additionally, you're going to hear a lot about this today, but I can't not say it now. Applicant initially filed its application for this uranium exploration permit nearly 2 years ago. We still haven't started the actual contested case hearing on that application. As Mr. Ellison commented, at 45-6D-28 requires a final decision to be made in a very timely manner, something that is not happening here. It's my belief, frankly, that the motion to continuance, the motion to continue is an effort to delay these proceedings and delay action on the application itself, action that the applicant is entitled to. Applicant has a due process right to be heard as well, and to be heard in a timely manner consistent with statute. I would urge this board to consider where we are, how we got here, who is here, and deny the motion to continue. Right? As it relates to the site visit, I can't help but comment that this is publicly owned. This is school and public lands property. Again, this application has been filed for years. Had it been necessary for applicants or, pardon me, for interveners to attempt to visit the site, they've had ample opportunity to do that. And the tribe's order for inspection that was filed recently provided 3 days for that opportunity. Certainly no need to delay this board's consideration of the pending appeals any longer. Thank you, Mr. Chair.
You know, one of the things that we might do to make some sense is to identify which interveners are here and which interveners aren't here. So if you are an intervener, could you please stand and state your name and make your appearance? Let's start. We have Mr. Ellison.
Yes, and Mr. Greenfield, I believe that a sign-in was taken of the people who were intervened and not. So there's also a written,
Yeah, we can't hear.
Please.
I believe that there was a sign-in, or at least.
Still can't.
The green when it's on? Okay, can you hear me? No?
That's
I'm a Luddite, so it may be the wrong button. Hello?
Oh, there we go. Now we're good.
I just wanted to note for the record that, and I appreciate the screen you going. Can you still not hear me?
Better now.
All right. Here. I thank you for doing this procedure. I believe there's also a written record, which I would like to make as part of the record, that when we came in the door, we were asked if we were an intervener or not, and we were checked off if we were. So I would ask that that also be part of the record, sir, as part of this.
It will be.
All right. Bruce Ellison, intervener.
Next.
Dr. Lilius Jarding, intervener.
Third. Yeah. David Gunhammer, intervener.
Denise Gallego, intervener.
Carla Cooley, intervener.
Sarah Peterson, intervener.
Third.
Dr. Ben Sharp, intervener.
Imataka Mie.
You have to start over.
Imataka Mie. Washitu, Chaje Washitu, Elizabeth Lone Eagle. Lakota Ahichita.
Thank you. Ma'am.
Good. So I am here as the Attorney General of the Cheyenne River Sioux Tribe, but we are actually represented by legal counsel, Steve Gunn, who represents the Cheyenne River Sioux Tribe and the Oglala Sioux Tribe, and he is not here. He has a different meeting that he's attending today. He was out on Craven Canyon the last couple of days. I asked him if he'd gotten notice of this hearing because we've formally engaged him to represent the tribes in this matter. And I don't think he has gotten notice of this meeting because he would have told me. I just saw it on an email from Rebecca that this was happening today. So I came over to observe. So I'm not here as the counsel for the tribe in this case. I've hired Mr. Gunn to represent.
Thank you.
Could you tell me your name? Kimberly Craven.
Any other interveners?
Jay Davis, I'm an individual intervener. I'm also the chair of the South Dakota chapter of Sierra Club.
Thank you, Jay. Yes,
Gina.
Bruce.
Sorry, somebody else.
Gina Parkhurst on the phone, intervener.
Were you able to get that name?
Gena. Gina Parkhurst. Parkhurst.
Any other interveners that are present online or by phone? All right. Thank you. Bruce.
Thank you, Mr. Greenfield. As I counted, there were, out of 35 approximately interveners, there were 13 were here by phone and present. Two of the very important interveners, the tribes, are not here. So therefore, the majority of the interveners, and I appreciate the attorney for the Cheyenne River Sioux tribe, but who's not appearing as the attorney in this case, pointing out that they did not get the formal notice. They found out the same inadvertently that I did.
I'm sorry, they didn't get formal notice. What?
They didn't get formal notice. They found out the same inadvertently that I did. So therefore, 2/3 are not here. I think it's a pretty good showing, sir, that due process would require that we have a hearing that really gets notice, that reaches the people who are on the ground, for the affected ones. That we at least be afforded the respect as well as the due process to allow all of us to be here. And some of us don't even have computers, a half dozen interveners. So there's no way, even if it was on the contested website, that they could find it. So with that, I'll finish. I've talked enough. I appreciate the time that the commission has given me. But really, let's just do this on another day. We can, if we push it back a month, even if you push the ultimate hearing back a month or two, which would be really the responsible thing to do, we can then take care of this in a regulated manner. Despite what Mr. Naz says, they may have submitted the application. Despite what Mr. Naz said, they may have submitted the application 2 years ago, but it wasn't okayed and put out for notice until about a year ago. So a couple of months isn't going to make a difference. If the difference is they get to start whenever it's convenient for them, the company, or whether we get actually meaningfully heard before this board, there shouldn't be a choice. And I would ask that this matter be continued. Thank you.
Any other interveners that care to comment? Yes, ma'am.
Dr. Lilius Jarding, intervener. In addition to the points that Mr. Ellison has made about notice of this meeting, I just want to point out that I received notice of the site visit, which started 2 days ago, yesterday. So there are some real notice problems all the way around, and I think that that argues for putting this off until everyone is properly notified and repeating the site visit and in a way that everyone is properly notified. Thank you.
Yes, sir.
Dr. Benchard. Yeah, speaking in support of Mr. Ellison's motion for continuance. And I would just like to say that procedurally, this entire process to date has given the impression that this board has outright contempt for the voters and the citizens of Fall River and Oglala Lakota counties and really the entire Black Hills. That's the impression that all of my neighbors and townspeople are getting. This is an opportunity to reset. It's an opportunity to start clean, to start to make it look like maybe you are clean, which would be not the impression that the voters of Fall River County have received today. The suggestion that by showing up, we waived our right to have due process and to receive formal notice, as if the word goes out. I think the board's pulling a fast one. I think they're trying to have a hearing without notice. Shoot, we better get to Pierre just so that witness to what they're trying to get away with. Oh, you walked through the door. Clearly you have, waived your right to due process under the law. If you want us to go back and tell the citizens they're not listening to anything you have to say, okay, this is your chance to either send that message or to start again, slow down, and start following some rules. Furthermore, if you're going to say that the terms of reference for this hearing are that it's legal arguments only, not evidence, well, that's news. I don't see that written in a statute anywhere. We need time to prepare for that eventuality. I would also point out that if you're operating on the basis of people telling lies, and I stand up to say, excuse me, sir, he's lying, under your terms of reference, sorry, Dr. Sharp, that's evidence, not legal argument. So now we have to just let the people get away with lying? You can't have a hearing with no evidence, with no factual content. You're treating the voters of our counties as if we're stupid, and they feel it, and they're not. They're not stupid, and they're also not pushovers. So I would suggest that maybe it's time to start restoring a bit of faith in government, and we can start right here. Everybody in this country has lost faith in Washington, D.C. in the last month. We all know what actually runs that cesspool. Are we supposed to get the impression that Pierre runs the same way? Dirty money and blackmail? I'm not saying that, but that's the conclusion we'll draw if you don't start following your own rules. So maybe it's time.
Yes.
And it's not just the hippies and the Indians. The cowboys are pissed too. You got us all on the same side.
Anyone else?
Is it working now? Hello? Can you hear me? Wow. I want to say, first of all, I'm not trying to be a jerk. So there's that. You know, the scheduling of this site visit, whatever the intent of the board or of the lawyers trying to negotiate it, what you've set up is a condition where all of the interveners are forced to choose a thing that on paper we didn't show up for. And I really resent the claim that this is so easy for all of us to be here, that this isn't a massive inconvenience to all of us. It is, and the lack of notice makes it even worse. So aside from that, I also heard a conversation while I was waiting for the bathroom between Bob Morris and Greg Greenfield about this motion for continuance. You seem to be talking about how to decide this, and I was just wondering if you could share that decision-making process with the rest of us. Thank you.
Oh, go ahead, Bob.
Be happy to.
Microphone,
He's not
please.
supposed to be.
Yeah, he's not supposed to be participating.
No.
Well, with that allegation, he's gonna participate.
You saying that didn't happen?
A conversation?
About how to rule on the motion for continuance?
There was no conversation about how to rule on anything.
Mr. Gunhammer was in the hallway. I came out of the restroom, Mr. Greenfield. We greeted each other. I pointed out that one of the objections is that the hearing I set was for the 18th, 19th, 20th. The objection was, I believe, that the 20th was solstice, spring solstice holiday, Native American holiday. And I merely advised Mr. Greenfield that I cleared my calendar so we could do the 17th, 18th, and 19th and not have the hearing on the 20th.
So did you not say you're fine with those dates and you've got that all figured out? You didn't say that?
No.
You did.
Oh, wow.
That was the extent of the conversation, was the hearing date.
All right. Any other comments? Yes, I'm sorry. I haven't. You had your hand up and I did not recognize you.
Oh, you want to comment?
Go ahead. After
Wanji, at our very first pre-hearing conference, the pre-hearing officer ruled that all service pertaining to this case, per the statute, South Dakota statute states that we can be served in person, by fax, or by US Postal Service. The fact that you all are discussing the fact that it was posted online is in violation of his order. Now, I can tell you that there's some orders due to the problems with the Postal Service that I have yet to receive, including the notice for the first pre-hearing conference in August. I still have yet to receive that from the mail. And that was apparently sent out in the beginning of August or end of July or something like that. I have no clue because I can't see the envelope with the postmark on it. So there are problems. I put in a motion to allow, and I think there was some others that also agreed with me, that we be allowed to be served electronically through email. That was denied because specifically he said, if you don't like the way the law is written, get it changed. Well, so far to date, that law has not been changed. So in accordance to his ruling, and this has to do with this contested case. His ruling was everything for this contested case, U.S. Postal Service. He did allow for us to submit just so it could be posted on the site so that people could look, but it would not be considered as official service until we got it in the mail. So there's a bunch of stuff I have not been served with yet, because I have not received it either by fax, nor in person, nor by U.S. Postal Service, including for this. Doesn't matter that it was posted on your website. There's a number of Lakota elders in Wounded Knee. One of them called me on Tuesday, the day that other interveners like myself were designated to be able to go out to Craven Canyon. He got it that morning. He was confused. He didn't, and I still haven't been able to fully read, to be able to make some determinations for myself about that order. So the first thing, okay, is that without ruling in favor of Mr. Ellison's motion for a continuance, you're violating the order of your own hearing chair. And I forgot my second point, but one of the things I'd like for you all to consider also, with respect to some of the things that have been commented on by other interveners, is that we're all here by choice. The choice that you all made when you accepted your appointments was to accept the responsibilities to the citizens of the state of South Dakota, which all of the interveners are, with the exception of the applicant. The applicant is from somewhere else. So your first allegiance is to the citizens of South Dakota. You made that choice. Mr. Morris, on numerous occasions, has indicated to us that this is inconvenient for him. Well, if it's that inconvenient for him or any of the rest of you, you might want to consider a resignation so that somebody who does want the responsibility and is willing to make the truthful, moral, ethical, legal decisions that need to be made can do that. I'm sure there's any number of the interveners that would not myself, but some of the other ones that would be willing to take on those responsibilities, because the fact that we intervened in the first place means that we do care. Individual interveners are not getting paid for this. The attorneys are getting paid to be here. I haven't looked at all the rules for these boards, but what, you get mileage per diem at least? We do this on our own dime. So I'd like to have that consideration, and the fact that has already been raised that people are really distrustful of government. And as a Lakota, we have a particular distrust of government that is very well founded. So I certainly hope and I pray that you take those things into consideration when you make your decisions. Concerning what was brought up about the, since it's already been brought up, about the hearing dates. I grew up being brought to church on Sundays. I was brought up preparing for Sundance. I was brought up preparing for our ceremonies. You know what the preparation for going to church is? You get up in the morning, you put on your Sunday clothes, put on your church clothes, you get in the car and you go. That's the preparation that I recall. Sundance takes a whole year for us to prepare for. Now, it's not every minute of every day, but the days that you're talking about, 17th, 18th, 19th, those are preparation days for us. And then once we participate in ceremony, for each day that we participate, we take 4 days of recovery, because our spirituality is connected to the land, and it physically takes stuff out of us that needs to be replenished. And there's not enough understanding among Lan Lakotas who have lived in this state their entire lives to understand what we go through. Because when we pray for you too. Because one of the things that we understand when it comes to this earth is we are all in this together, and ain't none of us getting out alive. Hilamae.
Thank you. Any other comments? Ma'am.
Good afternoon, or good morning, Kimberly Craven. I'm the Attorney General for the Cheyenne River Sioux Tribe, and I have not officially entered a notice of appearance in this matter. The tribe is represented by Steve Gunn, who we've hired to make sure that we are participating as fully as we possibly can, and he was really instrumental in organizing the trip out to Craven Canyon because he wanted to see firsthand what was at stake with this permit. If it were to be approved. And I just want to, Elizabeth is a hard act to follow, but I do want to say that the tribe, it does object to not being officially noticed. I don't want to have my appearance here being taken in that we are waiving the requirement of official notice to preserve what we see as very important due process. And we have gone to great lengths to make sure that we comply with all the due process notices by making lots of copies, putting them in the US mail, and ensuring that when we take an action, that everyone is properly noticed of what we are doing. And so we would just kindly ask that you all do the same with us, respectfully give us proper notice of hearings so that we can make. I would like Mr. Gunn to be here, but because he's busy with another meeting, I don't think he got notice of this. So it would be really important to preserve the tribe's interests to make sure that we are given proper notice of any hearings. Thank you.
Any other comments? Yes, sir.
Yes, I just wanted to add that I will say what I said under oath. No problem.
Yes, sir.
Chair, thank you, Matt Nas, Clean Nuclear Energy applicant. I think it's worth noting a couple things here. There were 18 interveners who signed the appeals, 13 of whom are here today. Tribes have not appealed any decision of the pre-hearing chair that is scheduled to be heard today. To the extent that there's a suggestion that the applicant has attempted to make a site visit difficult, I would say for the record that that is just certainly not the case. The tribes led that charge through their attorney, Mr. Gunn. You can ask Mr. Gunn. I think he would tell you that we have been cooperative every step of the way there. Just so to suggest that that is some reason to continue, I would strenuously object to that. As it relates to the continuance being considered right now. Hearing has been scheduled. The hearing on the merits in this matter has been scheduled for the middle of March. Arrangements have been made for witnesses, for client representatives, for expert witnesses. As Mr. Ellison said, the application was deemed procedurally complete by Daner a year ago. The applicant has a right to have the application considered by this board in a timely fashion so that it can make its plans as necessary.
Yes, sir.
Yeah, just very briefly again. I think the suggestion that, well, in this instance, breaking the rules doesn't really hurt anybody. We've been waiting a long time, so you can ignore your rules for, this time around. You can't have it both ways. You already heard from one of the interveners that we, meaning collectively the interveners, Chief in particular, made a very reasonable, given the resources of individual interveners to send mailings to the entire list, a very reasonable request to the hearing chair that service could happen by email, and was denied, saying, no, that's the law. Well, there's not rules for thee, but not rules for me, unless you want to say that. And if so, we can go back home to the citizens of our counties and say, I guess they're not listening. What's our next step? But if ultimately one of you should be accountable to somebody who's elected, and it is an election year, and frankly, I can't believe we're even having the conversation, well, maybe we could break this rule this time. It was not posted on the, regardless of electronic service versus paper service, this notice was not posted on the contested case website. It was only posted on the BME website. Who has access to that? That's not a legal process. You're making up new rules as you go along because you don't feel like you need to follow them. If that's the game we're in, okay, we'll go home and tell everybody that. But I don't think we really want to go there. Let's slow down and at least pretend that we still have a democratic government here.
Yes, ma'am.
I just want to put on the record an objection to some of the remarks made by the applicant's counsel. I think it's improper for him to be putting words into the mouth of the attorney for the Oglala Sioux tribe and the Cheyenne River Sioux tribe when he is not here to respond to those remarks himself, because he was not given notice to be here to respond to the remarks that he made. I asked, I'm not sure as a pro se, whether I can ask for those to be stricken from the record or for you to simply negate his statements. Your consideration.
Yes, sir. I just have a clarifying question based on council's statement. Are we to understand then that any scheduling of events by the board is irrelevant when it comes to site visits? We don't worry about that because the land is accessible? Is that what we're saying?
We can go anytime we want.
To whom are you addressing your question?
The board. It was basically offered up that because the land is somewhat accessible in general, that it doesn't matter that the scheduling was set up in a way that puts interveners at a disadvantage. So I'm wondering if that's the case.
That wasn't offered up by the board. Is there any, and as far as the record is the record. So we don't strike or we don't, it is what it is. Any other comments, any discussion or questions from the board of any of the parties?
Mr. Chairman.
Yes.
Lori Schultz. I do have a question regarding the site visit dates. Who set those? It wasn't the board. We did not set those dates for the site visit. Was it the department? Was it our responsibility in any way regarding this conflict?
Blair, do you care to respond?
Yes, Mr. Chair, Steve Blair, Department of Ag and Natural Resources. So Mr. Gunn is not here. Mr. Gunn, Mr. Nas and I were involved in a conversation regarding establishing those site visit dates. As Mr. Nas indicated, Mr. Gunn, on behalf of the tribes, took the lead on that. Contacted School and Public Lands to okay site visits with them because they are the owner of the property. And they signed off on that, and as long as their leaseholder signed off on it, and so Mr. Gunn contacted the leaseholder, who also signed off on it, and Mr. Gunn arranged those dates. As the department was not involved beyond, we felt no need to have a site visit. I mean, for us, not, for other people. And we're certainly willing to, accommodate to the extent we could a site visit. That's my understanding of how the site visit arose. I don't know what conversations Mr. Gunn may have had with other interveners or his clients regarding what date were the best for them. But on behalf of those of us that were involved in discussing with Mr. Gunn how that site visit would occur, that's my knowledge of how that happened.
Thank you.
May I, Mr. Chairman?
Let's go in the back first, Bruce.
Sure.
I just have a question about, they were talking about the conversation between the attorneys that did not include birthday interveners. At any point in those conversations, were dates discussed? If I can't imagine that a responsible attorney representing two tribes would purposely schedule a conflicting site visit with something he had, meeting like this, that he would have received proper notice of. When did these discussions take place? Before this meeting was set? And then why didn't we get the notice? And it's posted on the contested site or on the contested case website. It is posted there. I checked. So if it's posted there, then that gives the appearance to those of us that are pro se that the board did approve of this, or at least the hearing chair did. And you all knew, and especially the hearing chair would have known that there was a conflict there. So why didn't somebody step in at some point before those dates were set, or when that came into the office or came in through the email? Why didn't someone say, hey, there's a conflict here, we need to sort this out? Nobody did that. They certainly got the notice for everything. They knew everything, the applicant and the state's attorney, maybe even Mr. McVeigh. So there is an attorney or attorneys somewhere that are negligent in their representation. And I think, my own opinion, is that it's possibly all four. Mr. McVeigh, I can't remember the CNEC attorney, Mr. Blair, and Mr. Gunn, because nobody thought, especially since one of those dates was set aside for us, to have any discussion with us. Those of us that can be contacted by email, those of us that can be contacted by phone. There are ways, unless we stick to Mr. Morris's decision over and over and over again. You only allow service by fax, in person, or mail. Which means that site visit could not possibly have been scheduled for this week, nor could this hearing or this meeting that you're having now. Because Postal Service simply wouldn't allow for it. Thank you. Thank you.
Yes, ma'am.
Okay, I just wanted to point out, Mr. McVeigh had said that, well, this has been around for a year, so you could have gone out there at any time. But Mr. Blair did point out there are contacts with landowners and there is a process to go out to these sites. It's not as though we could have just gone out there on our own as individual, citizens to just walk onto private land. So that is incorrect, that even though this has been around for a year, that we could have gone out there at any time to visit those sites. And I don't think the maps were even available for us to see where the sites were, that we could have just gone out there on our own and examined it. That doesn't make sense at all. So that's what I would like to say. Thank you.
Thank you. Any other questions from the board? Are there any motions? The chair has its own motion. I want a motion to go into executive session to further discuss this.
Oh, Mark.
On the, no, on the basis of legal matters, we are allowed to do that by law. And so that's what we're going to do. There's the statute 125-2-3.
Allowed to market to be present.
I don't know who's
talking and I can't hear you, so.
If I may interject,
On the
ma'am,
basis of legal matters, as you just stated, that the attorneys in the room, all of them.
if I may interject,
Just stated.
the open meetings law, there's a section, SDCL 125-2, subparagraph 3, that allows an open meeting to enter into an executive session to discuss pending litigation matters with board counsel. And what the chair has requested is a motion pursuant to SDCL 125-2 sub 3 to enter into executive session to discuss the matter pending before the board among themselves with legal counsel to determine their legal obligations and rights, which is clearly indicated under South Dakota law for this specifically intended purpose.
Elizabeth Loney, the less pro se people don't need to be condescended to. We know what's going on. Yep.
Bruce, Mr. Greenfield, just, I just want to emphasize the board.
I can't.
Bruce Ellison, can you hear me now?
Yes.
Individual intervener. I just want to
I'm
emphasize.
sorry, one moment, Bruce.
Yes, sir.
Let's go back to the motion.
Yeah, no, I'm about the motion, but you want to go into executive session, sir. And I just wanted to comment that, which is related, that you're going to talk about this motion.
Which is what?
Which is related, I'm sorry, which is related because we're going to talk about the motion before the commission. I just want to, the general theme that we've been trying to impress upon you is transparency, the importance of that. When you go into executive session because you can, the statute doesn't say shall, it doesn't even say should, it says can. That means that you have the authority to do so. The question is it appropriate? And what do you want to discuss that you can't discuss in front of us?
Yep.
If Mr. McVeigh is your counsel, we should be entitled to hear why he's going to argue to deny this motion. Which is, I expect what you're going to do, isn't it, sir?
That's why we all drove here too.
And so I would just urge that, yes, I totally accept that you have the authority to do so. And if you make a decision to do so, it will be lawful. But I just ask that, we're here because we want to know what's going on. And if you're concerned, please don't be concerned about questions from people who may not be law trained. They may not understand, be experts on all the rules. Most people here are just citizens without legal training. Many of you are without legal training. So it's a question of what seems right and fair. And that's all I just wanted to say as a general theme as you go ahead, Mr. Greenfield, with your motion to go into executive session.
Well,
Thank you.
That was my motion, and I can do so. Is there a second to my motion?
Ask a point of clarification.
Doyle, second.
Law, please.
Pardon me?
The gentleman to your right, made a cited South Dakota law just now. Okay. You said executive session is justified in cases of pending litigation. What litigation are we talking about?
Right.
It's the contested case that's before the board presently, EXNY 453 is the
So litigation doesn't refer to a court case, it just refers to the actual contested hearing that we're already in.
It would, in this particular case, I mean, it's obviously a flexible statute, applies to many different situations. But as we're discussing it here, we're referring to EXNY 453.
So in that instance, your justification with reference to pending litigation, you're talking about the case that we're already in is pending litigation?
Correct.
But this is an administrative process.
I didn't know we were in a court case yet.
Yep.
It's a contested case here.
It's a contested case hearing, and that statute specifically refers to that. It's part of the open meetings law, and as we're discussing, I mean, what we're in right now is an open meeting. It's been noticed as an open meeting pursuant to the rules that, you know, you have to have 72 hours continuous notice, et cetera. And that's the publication on the open meetings website. And that, you know, that's all been done. So what we're talking about right now is moving into executive session to discuss pending litigation before the board, which is EXNI 453. So litigation does not,
I'm not getting any of
okay,
this.
if I may, litigation,
It doesn't matter.
yeah, litigation and being in circuit court are not synonymous. Litigation is a more general term than that.
There's a motion and a second. Is there any further board discussion?
What's it say?
Why don't you, I will call the roll. Oh, Doyle seconds.
Anyway.
No.
Excuse me, sir.
Go ahead. Go ahead, Brenda. Call the roll, please.
Ewing.
Aye.
Green.
Are you cutting her off?
Cutting whom off? No.
I have a
We're
question
voting.
on what is
We're voting
going
right
on,
now.
please.
We're voting on the
Okay,
motion. that-
I'm calling a timeout.
Yes.
I got nothing. You people are all talking at the same time and I got nothing. You got no.
My question was, I'd like this recorded. Are you
Hold
cutting her
on.
off? She's at the
Can
microphone.
you hold on?
Okay, I'm sorry.
Quit talking. Okay, if you want a record, then shut up and one at a time. All of you. Or I'm leaving.
There is, go ahead and continue. There is a motion that has been seconded. No further discussion. Brenda, please call the roll on the motion to go into executive session.
Ewing.
Aye.
Egg.
Aye.
Carbon.
Aye.
Miller.
Aye.
Morse.
Abstain.
Schultz. Aye. Blumhardt.
Aye.
And Greenfield.
Aye. We will go into executive session. The board will remain here. We kindly ask you to go elsewhere and we'll we'll have to see how long it takes.
You'll have, when we return to open session, someone will come out and get you.
Ms. McVeigh, maybe you could clarify if you would, please.
Oh, wait, and then, okay, hold on one second, folks. Hold on.
Hello? Hello?
We're still online. We're just muted right now while the board is in executive session.
are you, Jay? Long time. And keep busy. Me too. I'll make my own.
Actually, interestingly, this had that. That was pretty honest.
No, no. Yeah, that will be the first thing with.
Yeah.
All right, it is 11:48. We will come out of executive session. Pardon me?
That's the secret meeting, right?
Those comments aren't helpful. No, they're not. They're not true at all, and they're not helpful. And we have to have a method where the court reporter can keep track of what everybody is saying. So if you're going to make, just a second, if you're going to say something, you're going to stand up, you're going to identify yourself, you're going to be recognized by the chair, and then you can speak. Do we understand each other? I recognize you.
I was just wondering if, the part where the court stenographer told us all to shut up was gonna be on record.
Yeah, I'm a little alarmed that we just called into a meeting that started at 10 and we haven't been able to get through the Teams. The live link hasn't made us, it has been difficult to access. Finding the actual public hearing for this meeting was difficult. It reminds me of Hitchhiker's Guide to the Galaxy. Like, it was buried, and now you're chewing somebody out for asking if it was a secret meeting.
Are there?
Can I ask who this is?
Who are you?
My name's Elijah Small. I'm with Braveheart Society.
Yeah, I'm sorry, I didn't hear you. I just didn't hear you.
My name is Elijah Small. And I think that the gentleman who asked if it was a secret meeting had a solid question. Is it a secret meeting? We're not in it.
It's a
I didn't
meeting.
know it was happening.
It's a meeting allowed under the open secrets law. Let's go this way. I'm not recognizing you. Is there a motion to be made? Mr. Ewing?
Am I not a citizen?
You are not recognized by the chair. Mr. Ewing?
Mr. Chair, I'd like to make a motion for a continuance of this matter to March 18th. Seconds.
Discussion of the board. Discussion?
Thank you, Mr. Chair. Matt Noss for the applicant. Before I begin my comments, I would like to identify Mr. Jeremy Poirier, the CEO of Nexus Uranium, came all the way from Phoenix to be with us here today. I made my comments about the delay. I would request the record reflect, however, that at this time, the hearing on the merits is not being continued from the 18th of March. Is that correct?
Not at this time. So we have a motion to continue this matter until March 18th, made by Mr. Ewing. Was there a second? Dale seconded. Brenda, call the roll.
Ewing,
Aye.
Greenfield,
Aye.
Hague,
Aye.
Harpen,
Aye.
Miller,
Aye.
Morris,
Same.
Schultz,
Aye.
and Blumhardt.
The motion to continue passes. Are there any further motions?
I make a motion to move the overall hearing for the EXNI 453 permit, March, April 14th, 15th, and 16th.
Carpen seconds.
Just a sec. We have a motion and a second. Do we have discussion? Yes, sir.
Like I'm beating a dead horse at some level, talking about the timing again and again and again, but I'm left with no option here. I would remind the board that this application was submitted in March of 2024, be procedurally complete in March of 2025, pardon me, June of 2025, I apologize. The applicant has a right to have that hearing heard within 90 days, can be extended an additional 60 days in circumstances that are deemed unusual. That's not been decided by this board. It's not been recommended by DANR. Aside from the applicant's rights here, there are practical rights as well. The decision to hold the hearing in March was decided in January. Since that time, obviously, arrangements have been made to be here with you to discuss this important matter. And I would ask that you consider the expense and time and effort gone to arrange those schedules to be here in front of you in March when you consider this motion to continue the actual hearing on the merits of April. Again, I've done my best to make this record very clear. From the beginning of this contested case proceedings, the applicant has not waived its rights to be heard within the statutory timeframe. And need to make that abundantly clear again. Thank you, Mr. Chairman.
Thank you. Bruce.
Thank you. Member Chairman.
Chairman for a day.
I want to thank you for your early motion as well, but I also just wanted to mention, I appreciate Mr. Miller. Appreciate Mr. Miller's motion to put this from April 14th and 16th. That'll go a long way towards giving us or everything in a more appropriate order. The only thing I want to reference is that, and I know we're not arguing the motion about, well, I guess we did somewhat on timing. Got a lot of witnesses. 3 days is going to be really, really rough. And the only way to try and get through that is going to really be to curtail people's ability to question. To curtail people's ability to question. And no, I can only share 50 years of litigation experience. And also some of the members of this board who were here back years ago when we did the Dewey Burdock case. I think we got through about 5 witnesses in a week before the matter was remanded to the federal authorities for them to complete their work, which is still not done. So I just wanted to raise that for information because I would hate to get in a situation if you're making a meaningful decision that either you don't get all the information or that gets split up because we have to come back in 2 months or 3 months after that to complete whatever was there. So that would be the only thing I would mention. I do appreciate both motions being made by the board members and approval of the continuance of this matter. Thank you.
Doctor.
Thank you, Dr. Ben Sharp. First, genuinely, thank you for hearing us when it comes to the question of the continuance. It feels like this is at least an opportunity to begin what will feel like a legitimate due process that actually considers the rights of citizens of this state. With respect to appeals to the rights of the applicant, I don't know the law as well as you do, but I do know the applicant's the only party to this case that's not even an American citizen. Under the US Constitution, citizens have rights, And I would think that it would be remiss to listen to appeals of rights on behalf of a foreign corporation headquartered in a place dominated by Chinese money. You should look into that, British Columbia. Before you consider the rights of US citizens. The continuance is at the beginning of that process, and I thank you for it. I would like to support Mr. Ellison's appeal. We need at least 5 days. And I think it needs to be in Fall River County. Thank you.
These are beyond the scope.
Yeah,
If I may, I'm sorry, if I'm going to interject, these matters are beyond the scope of what we're presently talking about. There's a motion and a second before the board. And the board has the option to do your call at this point.
and the question has been called. Yes, please call the roll.
Aye.
Greenfield.
Aye.
Egg. Aye. Carpenter.
Aye.
Miller.
Aye.
Morris.
Aye.
Schultz. Aye. Blumhardt.
Aye.
Okay, we have, is there anybody that cares to make, or contribute pursuant to the public comment period in accordance with SDCL 1-25-1?
Oh, that will not be on the.
Hearing none, we'll move on. Upcoming board meetings we just set. I'm sorry, did you wish to say something?
Appeal on my name.
Thank you. Ma'am?
Marla Cooley. Also, thank you. I wanted to just respond to the attorney for the mining company.
Yeah, we're not going there.
Okay.
We're not going there. That's not part of the question. No.
It's not part of the question, but we decided in 22 we didn't want mining.
All right. You're off the record.
You're in the public comment period.
Right. We're at public comment period is done. We're at the last part, upcoming board meeting, and we just set the upcoming board meetings by our motion. So the next meeting will be 3/18/26. Okay?
And point of clarification, Mr. Chairman.
Yes.
Are we correct in assuming that the motion to transfer the venue to Hot Springs, which is very important to a number of the interveners here, including myself, will now be heard in this venue on March 18th?
Yes.
Okay. Thank you.
There are 4. So let's all, here's for the record. Now everybody.
You want this on the record?
Yeah, I do want this on the record. Everybody that's in here now has notice of the hearing. Everybody has notice of the hearing, 2 hearings, okay? We're not gonna replow that ground. The next time we meet, I will be chairman again, okay? So chairman for 2 days. And the issues that will be considered at such hearing are not pending decisions by Mr. Morris, but final decisions made by Mr. Morris, which include, 1 is venue, 1 is the effect of the Fall River ordinance, 1 is the motion in limine on quote unquote use of the word mining. And I gotta look here. That's it, because we did scheduling order. So
Wasn't there also a treaty, motion limited for treaty issues?
No, it was.
that's deferred, and that will be up to Mr. Morris to rule on that motion. But we can only act on decisions of Mr. Morris.
So in other words, that if Mr. Morris were to make a decision on that issue before March 13th, and we file a quick appeal. 18th, I'm sorry.
Yeah.
Thank you, sir.
And this statute is very unclear. I can't even call, I'm not willing to say it's an appeal. I'm not willing to say it's a hearing. What I'm willing to say is that it is a request to overrule the hearing chair. And what came about in this was that whether or not that statute has a due process requirement stated within the statute, due process exists within the Constitution of the United States of America as well as the state of South Dakota. So if you wanted to know what went on in this hidden secret meeting, not my words. Those are the things are discussed. Yes.
I just have a question. I submitted several earlier. That was all. I did preemptively. The board that I even sent to the secretary. And that was ultimately denied after that. So with the, I wasn't able to be present on the 6th. I had a family medical emergency. And so I missed meetings. Do I need to reappeal?
You do not. That motion has been served. That motion has not been ruled upon. That motion will also be
And would I be able to argue for it?
at the next time around.
Chairman, I move to adjourn.
Thank you.
Okay, there's been a motion to adjourn. Seconded, all those. I did close, I thought. Yeah, I did close public comment. Motion to adjourn. All those in favor say aye.
Aye.
All those opposed?
Aye.
Same sign, meeting adjourned.